Morning.
Lordship, bail application number 832. It was listed on 21/3/2024 and fixed for today, but not listed today in cause list, Lordship. For hearings, Lordship.
Find out.
May it please, Lordship. With the consent of the addressor, I beg to mention item number 25.
20?
25, Lordship. In this case, Miss Arbora is appearing, Lordship. She is unwell today, Lordship.
Arbora for?
Agriculture Department, Lordship.
Have you informed the petitioner?
Lordship.
Time for the respondent, Lordship.
S prayed for by MS?
Z Bora, Lordship.
E Bora?
Z Bora, Lordship.
E Bora, Learned Counsel for the respondent number?
Respondent number 1.
For the respondent number. You are making a
Lordship.
mention and you do not know which respondent you are appearing for?
1, Lordship.
Are you sure or not?
Sure, Lordship.
Check the file and then we will grant you the mention, but you check the file first. Yes, next.
I'd like to mention item number 10 and 11 of today's list.
10.
10 and 11, my lord. Matter, my lord, yesterday only division bench has passed a judgment where the opposite party have reliance upon that. My lord, we are waiting for that reply. Can we
Heard
vacation?
MS
And Gogoi.
N. Gogoi, Learned Counsel for the petitioner. Stop. MS N. Gogoi submits that there has been some development in the matter and she wants and accordingly seeks some time for verifying the same. Stop. List after?
Due vacation, my lord.
List after 2 weeks and a date to be fixed by the registry.
I have another prayer, my lord, regarding item number 12 to 22, my lord.
This is a 2015 matter.
Yes,
Wait
my
for
lord.
your
Some
turn.
accommodation, a fixed date may be.
Wait for your turn.
My lord,
Yes.
at 2, my lord, then. At 2. Hello.
At 2.
May I please, Lordship? I beg to mention item number 29, my lord.
20?
29, supplementary admission column, my lord.
Yes.
I am appearing for respondent number 6 and 7, power grid, my lord.
Have you taken consent from the other side?
Yes, my lord.
Why do you want accommodation today?
For filing of my wakalatnama and affidavit in opposition.
Your name?
H.K. Sharma.
Mr. H.K. Sharma, Learned Counsel for the respondent submits that he has instructions to appear on behalf of
Respondent number 6 and 7.
respondent number 6 and 7 and accordingly is going to file
Wakalatnama
the
as well as
requisite
affidavit.
power. Stop. As such, he seeks some accommodation. Prayer is not opposed by the petitioner. List after
3 weeks, my lord.
3 weeks. Who is appearing for the petitioner? Mr. Day?
My lord, I am appearing for the
When 2 weeks. List after 2 weeks and a date to be fixed by the registry.
Achha.
Item 3, you want to withdraw? Item number 3, your name is?
MS Hussain on behalf of AM Bora.
Your name.
MS Hussain.
Heard Mr. M. N. Hussain, Learned Counsel for the petitioner. Stop. Also heard MS. A. Begum, Learned APP for the state respondent. Stop. Mr. So-and-so Hussain, Learned Counsel for the petitioner submits that he has received instructions that the petitioner does not wish to press the instant bail application. Stop. Accordingly, he seeks for withdrawal of the same. Stop. In view of the aforesaid endorsement made by the Learned Counsel for the petitioner, the bail application stand disposed of on withdrawal.
Much obliged.
I am extremely sorry. Respondent number 2, Lordship.
And so when you are not sure, do not make a mention.
Lordship, sorry.
You check up the records. There is no difficulty. We will always try and accommodate the lawyers, but we expect that the lawyers also, the counsel also has a duty to the court, right?
Yes, extremely
So check the facts before you make a mention. Respondent number?
Respondent number 2, Lordship.
What was your item number?
25, Lordship.
In item 25,
And the petitioner
MS
here?
so-and-so, 6, wanted time to file affidavit.
Lordship,
What was your prayer?
Lordship, up-to-date instruction, I am not in this matter, Lordship. Arbora is
I am
handling,
for
Lordship.
respondent TN4, Lordship. What time last occasion, this could directed to take up-to-date instruction, Lordship, to the respondent number 2, Lordship.
In item number 25. 25?
25.
Respondents seek time for furnishing the up-to-date instruction in the matter. Stop. Prayer not opposed. List this matter after.
In the month of May, Lordship, has to
List the matter on a date fixed by the registry in the first week of May.
Highly obliged. Sorry, Lordship.
Yes, next.
May I please, Your Lordship? With the consent of the other party, I beg to mention item number 8 and 23 of the daily list.
8.
8 and 23.
8 is a 2019 matter. You wait for your turn. And the next matter is 20.
3. Your Lordship, the senior engaged counsel, Mr. James
23 is a 2015 matter. Wait for your turn. Next. We will see when the matter is called. You wait for your turn. It's a 2015 matter. We are not. This court is not going to adjourn it at the time of mentioning. Yes. Next matter, please. Yes, Mr. Mahmood. This is bail.
This is my second application for bail.
You have the up-to-date case diary,
Lordship.
You have
There are
Up-to-date case diary, Lordship.
There are mainly three grounds, my lord. First thing, my lord, after rejection of the earlier bail application, already 13 days have passed. Secondly, my lord, the petitioner is suffering
after the first bail rejection. What has passed?
13 days.
13.
13.
So total how many days?
Total 45 days, my lord.
45.
And co-accused has been granted bail who was in similar situation, my lord.
Co-accused already are on bail.
Baharul Islam, he has been granted bail. Now, Lordship, kindly see, the other day, the learned PP said that everything was recovered from me. Kindly see page 16, my lord. Kindly see 16. All the seizure articles were Javed Ali, the present petitioner. I am showing the original, that is page 18, kindly see, page 18. Page 18. Second paragraph. I, the undersigned, do hereby seize the following descriptive articles items in connection with the above reference case on being produced from the possession of Muhammad Javed Ali, Muhammad Azad Ali, Abdul Kalam Azad, Muhammad Baharul Ali, and Hussein Ali. So, my lord, all these articles are recovered from the possession of all the accused persons.
You are?
Baharul Ali is granted bail long back, my lord.
No, you are?
I am Javed Ali.
Number 1.
Number 1. So, all these persons from whom the counterfeit 500 notes were recovered. And the other day it was submitted that it was made impression that those things are recovered only from my possession.
Which is the order? At which page?
Page 28. Your Lordship, relevant portion is also about page 27, but relevant portion may be seen page 28, my lord. From para 4 onwards.
No.
28, para 4 onwards. Proceedings see here, the further submit the seized articles have been made from the possession of the petitioner. It is not fully correct, madam. From the possession of all the accused persons. Among those, all these, Baharul is granted bail. Others, perhaps I have no idea, but I have been given the impression by the lawyer at Kokrajhar, who sent the case, that
earlier you submitted 60 days.
45 days.
45 days, Lordship. As earlier rejected, Lordship, we will bring CD in short date, Lordship. 8 of up-to-date CD, Lordship.
I asked Ms. Begum and you said it is available.
No, not this, Lordship. That is 4, 5 and 6.
No. Right now, item number 2 is going on. In item 2, do you have the...
No, Lordship. We
Then
don't
say
know.
that.
Obliged, Lordship. I am very sorry, Lordship.
Give the impression that it is there. That
No,
is
Lordship,
why
no, Lordship,
so much
no.
judicial time has been invested in
Lordship,
this matter.
I'm very
Otherwise,
sorry,
why should
extremely
we
sorry.
unnecessarily look into the case
Extremely
right
sorry,
today?
Lordship.
Up-to-date case diary, fix on 8/4/2024.
8 for all.
This is that
Item
yesterday's
4 and 5
matter.
are the same thing.
That one, Lordship.
Yesterday's matter. Similar. Where is the order?
Your Lordship, you can go.
Except the change in the name of the petitioner,
Yes, yes.
everything will remain the same?
Prime accused are Lordship Rohim Batsa and Bilal Hussain, Lordship. They are the prime accused, and Some were the co-accused who have been attacked them. Three of them were already arrested.
Ms. Begum, against the Saurav Ali, anything there? There are four petitioners in this.
Lordship, no Lordship. May I read the name of those who are...
1 second, yes.
Lordship, Rohim Bacha, Bilal Hussain, Abul Hussain, Yaqub Ali, Asiruddin, Ashrabul Islam, Johirul Islam, Alek Chan, Musa Sheikh, Motleb Ali, Sokat Ali, Morfat Ali, Sukur Ali, and Sabdar and Sunaullah.
No,
They are not named.
I am saying that.
But these three are, that means no adverse.
No.
So same order.
Same order.
All right, OP.
Same order, but this time, Lordship, let's say that send back the CD, Lordship. We will send.
Yes. Can be
Name
done.
of the petitioner with back CD. Disposed of.
এই শব্দের আলী নাকি কেলেকা?
Shabder Ali, I think there is. I think
Sokat Ali, Sukur Ali, Sabdar.
Shabder Ali, there is some materials, right?
Lordship.
And what about
Witnesses.
Syed Ali and Abu Bakr Siddiq?
Abu Bakr Siddiq is not there, Lordship. Once again, I will read it, Lordship. Rohim Bacha, Bilal Hussain, Abul Hussain, Yaqub Ali, Asiruddin, Asabul Islam, Johirul Islam, Alek Chan, Musa Sheikh, Motleb Ali, Sokat Ali, Marfat Ali, Sukur Ali, Sabdar, and Sunaullah.
Shabder Ali.
Only Sabdar is there.
Shabder
Lordship.
son of.
সরব
That one I will have to see, Lordship.
What is the material against him?
Lordship, they were in, when they came to attack, Lordship, he was also in the group, Lordship.
Shabder Ali.
Sabdar Ali.
Was in the group. Any role attributed to him?
শব্দের আলী সরব বারুশে
That
Role. He be
no,
present.
no, I have seen, Lordship. Sabdar, but in the Lordship note of IO, Lordship, Sabdar Ali's name is here, but IO
Ms.
says
Begum, his
that,
name may be there,
name
but
is
you
there.
see, we are considering a anticipatory bail
That is-
application.
that is
So
what-
my specific question to you: any role ascribed to Shabdar Ali, or it is his mere presence?
They were present.
They were present,
Present.
but no role ascribed.
That is not reflected in the CD, Lordship.
Where is that order? That's him. Begum, since Abdar Ali, except his presence, nothing else is there, so this court is allowing him also.
Lordship.
If there were something specific against him, of course,
That is not, and in the IO's note also, there it is written that sufficient materials are not against those people.
that is
A group
why,
of
you see,
people. That
my
is,
specific query to you was that.
that is not.
Only that.
But it is 302, so I am making
Absolutely,
clear.
absolutely. We all have to ensure
They are
all
largely
checks are
done.
done. But when there is nothing specific against that person,
They were
then
present,
there
but
is no
Lordship,
reason
that is
why
Lordship.
his liberty has to be curtailed,
Lordship,
isn't it?
Lordship.
It is ultimately his liberty that we are concerned as of now. Here, same. Submissions of A. That the investigation has not collected any adverse materials at this stage against the petitioner number 2 and 3.
Yes.
Stop. She further submits that though the investigation officer has, though there are evidence collected by the investigating officer to show that the petitioner number 1 was present
Yes.
at the place of occurrence, however, no
overt act.
no overt act, no materials to show overt act against the petitioner number 1 has been collected. Stop. Disposed of.
Return the CD, Lordship. Send back the CD.
Send back CDs in both cases.
Much obliged.
Yes.
Five,
5 to 2?
same.
4 and 5.
খুঁজো।
Lordship, scan copy was called for Lordship. I have gone through the scan copy, and Lordship, the last order is Lordship of 21/2/24. That is charges frame under 22C29 NDPS Lordship. NDPS, and it is fixed for evidence on 23/2024. Maybe evidence is started 23/2024, but as the case the scan copy is here, so we are unable to know that.
So that means trial has started.
Maybe it is Lordship. It is for evidence, and
if it has been fixed for evidence, trial must have been.
Lordship.
May submit.
Earlier, this court has rejected. Why is this matter before this court?
Page 29, Your Lordship.
Rejection of this case.
He was on court bail. He used to appear in the court, but on some dates he failed to appear. Accordingly, NBW was issued.
But why is this matter before this court?
क्यों ये तो कोर्ट उठाने से ला? Reject हुई से नहीं गया थे?
No.
Not reject, huh?
Act before on.
Supply in the supply list it is there.
Was Noor Muhammad anyone related to this case?
My Lord, out of the same case, Your Lordship.
Same case.
He has been released on bail, Your Lordship.
ये करने आई थी.
Where is that order?
Who does that? Susmita. Huh? That bench. Lordship, it is from subordinate bench, Lordship, Suspita Fukan Khan, Lordship. Then it will go to that bench only.
Correct.
Appropriate bench.
Correct. Is before appropriate bench.
On Friday, my Lord.
Next. We will do it. Make a request before the registry.
Council Mr. B. Datta is.
Council Mr. Item number 6. After some time. Eviction. Railway.
Matter, my lord. In fact, there were 2 writ petitions. The other one got disposed of on 11/3/2024, my lord. I can hand over the copy of the judgment. This honourable court has held that, my lord, that the petitioner doesn't have a cause of action. They are not affected parties, so this writ is not maintainable.
Are you aware of this?
Yes, sir, he was the counsel.
The same order?
No, Lord, see, in this matter is we are challenging the impugned judgment also. In this, there was a process of under section 4 and 5 of PPA.
1 second. Paragraph
6, 8 and 13. Similar cause of action.
Here also none of the petitioners who were
The society has filed the writ petition, my lord.
persons, they are not
Persons against-
aggrieved.
Not, my lord. Persons against whom the orders were issued, they were not before the tribunal. Even before this court, they are not parties, my lord.
The affected persons are not before this court.
No, not before this. Even before the tribunal, they were not there, my lord. So connected matters, my lord. This one got separated from
And the affected persons did not appear at the time of hearing.
never, my lord.
Lord, see, my submission is there.
There is an order of this court. The court has already found.
But two different decisions, Lordship. In earlier one was provision of PP Act was followed, Section 4. And in this case, PP Act provision was not followed.
This is in respect of a different land.
Yes.
Different land.
License, Lordship. In this matter, paragraph 18, Lordship, specifically in the judgment, Lordship, that is.
Where is the eviction order in this case?
Page 73 to 145, my lord.
Page
Not
70.
order, it's only license.
Page 73 to 145. These are the orders issued to individual persons, my lord. These were orders issued to individual persons. None of them.
These are cancellation of license.
License, my lord. None of these persons were before the Senate court below, or even before this court, my lord. So how this writ petition is maintainable, my lord?
This series is from 37. The cancellations orders
Page 73 to 145, my lord.
23 to page
145.
145. And where is the order of the court below?
Page, it starts from page 299.
99.
99.
Where from can we see that they are not before that before the court?
So the cause title itself, my lord.
299.
299. The appellant, my lord. Okojan Sarvajani.
Some committee has come.
Committee, my lord.
And these all persons are the members.
And this particular fact has been recorded in paragraph 8 of the judgment itself, page 304.
Page 304.
It runs up to 305, my lord.
Relevant portion is at page?
Page 304, regarding, my lord, the affected parties.
Yes, it starts from 301, right?
Judgment starts from 299. The paragraph 8, lordship will find at 304, my lord. In my copy, it's marked as 304. Paragraph 8. Paragraph 8.
Yes. Apparently.
The
Now, appellant is a society name so and so.
next page. No copy of the resolution of the said committee showing that its president was authorized to file this appeal has been submitted. No power of attorney whereby the president so and so was authorized to file this appeal. These are finding of facts.
Yes. And then?
Ultimately, my lord, it was held that this appeal was premature.
Against that, this writ petition has been filed. The writ petition is challenging that order.
That order. In fact, this is not maintainable because the affected parties are not before your lordships.
Here, eviction notices are on record.
Yes. Page 70, no license cancellation order.
Correct. What about the eviction orders?
There is no eviction order. This is the cancellation order. And
eviction notice. Before cancellation, no notice is given.
No notice is given because they were licenses. In the other case, they were unauthorized occupants. There was no license, my lord. In this case, these particular persons were licenses. Their licenses have been cancelled and they have been asked to vacate. So there is no eviction order under Section 5 of the Public Premises Eviction Act. So if they are aggrieved by this order, they should have filed an appropriate application before the Court of Civil Jurisdiction, my lord. Anyway, that is not the issue, my lord. The main issue is maintainability because the society cannot maintain a challenge against these orders, my lord. It has been decided.
The issue of maintainability of the writ petition is already decided. So,
and on lordship, in this matter, lordship, in this matter, they have not followed the PIL provisions.
Maybe, but in
Now
that case,
these persons affected
see,
persons,
this is not a PIL, right?
Lordship.
Now the affected person has to come.
Lordship, they through the society they come, lordship, and
Where is the authorization? At page 305 in paragraph 8, it is already clearly mentioned, no authorization given. Read paragraph 8 of 305. Mention no authorization.
Lordship, page number 165, lordship, there is.
You first read page 305, para 8.
Yes, lordship, but that only.
Please read.
That one will have challenged because we have filed the resolution, Lordship. Present 165.
First you read that paragraph.
Lordship.
Appellant so-and-so
Society named Bokajan Sarvajan in Kalibari Committee, registered under Society Act. Name is represented by its President, Sri Chandan Patel. Submitted no power of attorney where the Presidency advocate appearing on behalf one person, only the person who became aggrieved.
Only
the person who became aggrieved and injured in order can prefer and appeal against the Code of Civil Procedure.
So your case is that the authority was there?
Yes, Lordship.
Where?
Page 165, Lordship. And list was also there, all the affected members.
Where have you resolved that you will, they are authorized to file a writ petition? A case? Where is that? Mr. Counsel? Where is that authority at page 165? Mindful of what you are submitting in the court.
All members are all of the members.
Where is the authority? Try and understand the question that is put to you by the court and then answer. You are asking something, you are answering something else. Where is the authority at page 165, Mr. Counsel? You see, you have already you had appeared in the earlier case where this court said that the writ petition by the so-called committee is not maintainable because the members who were affected had not come. Correct? On that ground. Similarly, in your case, the licensees whose license have been cancelled are the affected parties. They are not before the court. And the committee that has filed, you are not being able to show any authority in favor of the committee by these affected people. Where is that authority? Court below has already recorded that part, that there is no authority in support of the representation. Then
all members were represented by the society, Lords.
Counsel, is that sufficient?
Lordship,
If there is a resolution, the resolution will matter. The resolution who has signed has no relevance. What is the resolution for? Where is the resolution that these members have authorized the committee to take action in behalf of them, to file writ petitions? Where are those resolutions? You expect this court to read those resolutions into this at page 165? Can these be inferred then? Please don't make submission for the heck of making a submission. Kindly
paragraph 18 mainly. There is no document on record showing.
Paragraph 18 of?
Page 308, Lordship.
.308.
Lordship.
Yes.
Advocate has argued that in requirements laid down under Section 4 of the Public Premises Act, decisions heard in the case law mentioned, no document on record showing that any notice under Section 4 of the Public Premises Act.
Your appeal was dismissed. Their appeal was dismissed.
Their appeal was
and that against that this writ
this writ petition, Melon. On two counts, that appeal was dismissed. Firstly, the affected persons have not come before the court. Secondly, it was held to be premature, my lord. Premature. I'm not making a submission on that, my lord. It's not at all premature. At this stage, Lordship may not go into that aspect of the matter at all, because the issue here is the maintainability of the writ petition.
All right.
So far as the aspect of premature is concerned, my lord, that it is not at all premature, because they were licenses, and we can resort to other provisions of the Railways Act, my lord.
Right. You are Mr. S.B. Prasad? Heard Mr. S.B. Prasad, Learned Counsel for the petitioner. Stop. Also heard Mr. B. Sharma, Learned Standing Counsel, NF Railway.
Yes, ma'am. B. Sharma.
You want to say something?
No, nothing. I missed the line. I missed what has fallen from your lordship.
Yes.
Sorry, ma'am.
Counsels, you may take your seats now. This writ petition has been filed against the impugn order dated 30/12/2014 passed by the Senior Section Engineer Works, NF Railway, Dimapur, and orders dated 22/1/2015 and 14/2/2015 passed by the Divisional Engineer /4 NF Railway, Lamding, issued to the petitioner members asking to vacate within 10 days. Within 10 days. Stop. The brief facts of the case is that the license of the members of the petitioner society or committee?
Society.
Petitioner society petitioner society were cancelled on the ground that the land is required by railway for its work. Stop. The writ petitioner, which is the Bokajan Sharba Janin Koilabari Committee, represented by its president, challenged the said cancellation orders issued by various persons by filing the then writ petition. $299, right?
Judgment.
The petitioner committee preferred an appeal under Section 9 of the Public Premises within bracket Eviction of Unauthorized Occupants Act 1971, being Miscellaneous Civil Appeal Number 01 of 2015. Against the aforesaid cancellation of licenses of the members of the petitioner committee. Stop. The said miscellaneous appeal was disposed of by the court of the District Judge Karbi Anglong with a judgment and order dated Order dated
9/2017.
I think it is 6/11/17. 6/11/17, correct? Please check that at 308. 6/11/17, by holding that the appeal petition by holding that the appeal petition was totally silent as to who were the members of the present writ petitioner society. Stop. Accordingly, the court of the district judge so and so held the aforesaid appeal not maintainable.
And there was no resolution authorizing that.
Mr. So-and-so learned counsel for the petitioner submits that the members of the petitioner society are the affected parties, and on behalf of them the society has filed the appeal before the court of district judge so-and-so. Stop. He further submits that accordingly the writ petition is maintainable. Stop. Mr. B. Sharma, learned CG's
Railway
Standing Council NF Railways, on the other hand, submits that the writ petition is not maintainable. Stop. He further submits that there are no authorization on record so that the society has been authorized by the affected parties to file the present writ petition. Stop. He further submits that there was no letter of authority brought on record before the court of the district judge so and so at the time of hearing of the appeal, and as such the appeal was held not maintainable. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop.
Paragraph 18 law.
I've said about submissions of the learned. Add one more thing. He further submits that the appeal was held to be premature as no document was brought on record to show that requisite notices under section 4 of the Public Premises Act were served to the members. Pertinent to refer the cancellation orders of the license of lent enclosed as Annexure 8 within bracket 1 series the writ petition. Stop. One of such cancellation order is reproduced hereunder for ready reference. Quote unquote page 73. Perusal of the said orders enclosed as Annexure 1 series from page 73 to page 145 indicates that the licenses of individual persons were cancelled by the railway authorities. Stop. Though the aforesaid persons appears to be members of the petitioner committee, no letter of authority has been placed before this court. Stop. Further, it appears from paragraph 8 of the court of the order of the appellate court dated 6/11/2017 that no authority was produced before the appellate court either. Stop. Paragraph 8 is reproduced here under for ready reference. Paragraph 8, quote unquote, page 303-304. It is absolutely clear from the above reading of the relevant paragraph that there is no whisper in the appeal memo as to how the appellant society became aggrieved with the impugned orders. Stop. Appellant society being not aggrieved cannot by any stretch of imagination be said to be an affected person and or aggrieved person, and hence does not have the locus standi to maintain the present writ petition. Stop. As such, there is no merit in this writ petition. As such, the writ petition is not maintainable, and hence is not maintainable. Stop. However, considering that the writ petition is not maintainable, this court is not going into the merit of the case and dismisses the writ petition on the question of maintainability. Stop. Issue of maintenance. Stop. Accordingly, the writ petition is then dismissed.
Much.
Yes, Mrs. Ayala.
I have received the record. In fact, my lord, there is a Bakija case, it appears. Already at page 40, my lord, Bakija case is there. And the principal and some interest has already been paid by the STC. My lord, difficulty is there, my lord. They are facing some difficulty, my lord, only.
What is the case?
Your Lordship, the husband of the petitioner number 1 was died, Lordship, in a motor. Thereafter, filed before the MSCT. And finally, Lordship, that petition was disposed of by the judgment dated 27/11/14.
What is this writ petition for? For non-payment of?
Yes, Lordship, by the STC, Lordship.
But already...
Non-payment of what? The awarded money?
Yes, Lordship. Non-payment of the awarded money. Now, Lordship, during the pandemic, pursuant to those orders, part payment was made, Lord.
Still there is some balance. How much?
On the last occasion, Lordship, the balance, Lordship, is...
Yes. So there is no dispute, Mr. Sahewal, otherwise. Now the question is when this balance amount shall be paid. Correct?
Some interest has been paid.
So therefore there is no dispute to this. Only thing is now within how much time you can liquidate the entire amount. That is the issue?
Yes, Lordship.
Yes.
As of now, Lordship, the 5,68,107.
5,68,175.
175.
Out of?
Out of
the total?
The principal has been paid.
Principal is paid.
Paid. And
This
some
is
interest has been paid. But this is the interest amount.
This is so how much more time? We finish it within 2 months.
Maybe 1 year, my lord.
No. 1 year, Mrs. Sahewala.
By installment, my lord, STC is running in
5 lakhs, Mr. Sahewala. 3 months. We can dispose it off if you can give us that assurance.
My lord,
3 months.
My lord, your losses may pass the order, my lord. Whatever, my lord, 6 months may be given, my lord.
6 months?
6 months, my lord. My only thing, my lord, that may be within 6 months, my lord. That.
Even Lordship, 2 affidavits have been filed by the ASTC Lordship. They have stated that Lordship, they will remaining amount on affidavits were filed on Lordship 1,
well, maybe
on Lordship 11/9/2000.
But Mr. Counsel, you see now the learned senior counsel is saying within 6 months
Yes, Lordship.
They will liquidate it.
Yes,
so do you want this court to go into the affidavits? We can dispose it off on the assurances made.
Yes.
Simple. We'll give them 6 months time. Within 6 months they will liquidate. We will not specify in what manner. It is to their discretion. Right, Mrs. Hayawala?
Well,
Mrs. Hayawala, please do appreciate that this order, this court is only passing it because you are saying it. So, I'm quite sure that you will ensure that this money is paid. Because otherwise, no point of keeping 5 lakh rupees pending. And when there is no dispute to the merit of the claim. All right. Heard Mr. M. Ahmed, Learned Counsel for the petitioner, stop. Also heard Mr. G. N. Sahewala, Learned Senior Counsel, assisted by Mr. Miss G. Duggar, Learned Counsel for the respondent ASTC. And also Mr. S.R. Borwal, Learned Standing Counsel, Government Advocate for respondent number 2 and 3. Stop. Writ petition, the case of the writ, by preferring the writ petition, the petition is canvassing the inaction of the respondent authorities in not releasing the compensation award granted in favor of the petitioner. It is said certificate, with a certificate, dated
Judgment dated 27.
With a judgment and order dated
27/11/2014.
27/11/2014. Where is that judgment,
Page
Mr. Ahmed?
number 26.
Page 26.
Yes.
Case of the petitioner is that on 10/12/2009, the husband of the petitioner number 1 called down from a bus of the Assam State Transport Corporation, succumbed to such injuries on 12/10/2009. Were referred before the motor tribunal, whereupon by an order dated 36
27/11.
Yes. Whereupon by an order dated
27/11/2014.
7,45,500 was given.
47,500.
Whereby by an order dated 27/11/2014, in MAC number 57 of 2010.
Yes.
An award of rupees 7,47,500
with interest of 6%.
With interest or at the rate of 6% per annum was granted in favor of the petitioner stroke claimants. Since the aforesaid award was not paid, therefore the writ petition was filed. Present writ petition has been preferred. Stop. During the pendency of the present writ petition, principal amount and some amount of interest was paid to the petitioner. Stop. It is submitted at bar that a balance of rupees 5,68,175 stands outstanding as on date. Stop.
I cannot confirm it, my lord, although it is there, my lord.
Yes.
Yes. That may be mentioned.
All right. Mr. G.N. Sahewala, Learned Senior Counsel, submits on instruction that the remaining balance amount after verification can be shall be paid to the petitioner within a period of 6 months. Stop. Is it all right? After verification. In view of the aforesaid endorsement made by the Learned Senior Counsel appearing from ASTC, this court is of the considered view that this writ petition can be disposed of with the direction to the respondent authorities, particularly respondent number?
Respondent 4 and 5.
Respondent number 4 and 5. Respondent number 4 and 5 to pay the balance amount after verification to the petitioner within a period of 6 months from today. Stop. A copy of the a certified copy of the said order be furnished to the. With the aforesaid observation, this writ petition stands disposed of.
Highly obliged.
Transfer case. Why? Why?
Your Lordship, because this investigation that was done by the state police.
Not satisfactory to whom? On what grounds?
Because the petitioner's son is missing since 2008. As per the status report, you have submitted 2 status reports, Your Lordship. They transferred the case to the CID, but that too was not satisfactory. Is given an additional.
Missing since when? Petitioner's son is missing since when? 2018. Status report has been submitted.
Yes, twice, madam.
Where are they?
That is first
29/2/24.
That is second, my lord, and earlier, my lord, 9/1/24.
This court can take this matter, right? Not sure, but earlier, at some point, I may have appeared in this matter for government. Not sure if this is the same matter or not. Just check once.
Yes, sir.
Just wait for some time. Next material. Supplementary Vic. Yes. Structures. 27. Your name?
Yashri. H Das.
Huh?
H Das.
MS H. Das, learned counsel, or you say heard MS H. Das, learned counsel for the petitioner. Stop. Also heard
Borwa.
MS S. Borwa, or learned counsel for respondent number
1 and 3.
1 and 3. Learned government advocate. 1 and 3. Stop. MS so and so, learned counsel for the petitioner, submits that the writ petition has become infructuous. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the writ petition stands disposed of on being infructuous. আকৌ এবাৰ কল কৰি দিওঁ গোটেই file.
I received a telephone call from the chamber council that is why I have not.
You are for? You are for the petitioner. So if you are MS SB Chaudhary?
Yes.
Mrs. Chaudhary, you are a senior member of this bar. If you receive calls from the other side, do you not come to the court without the file? This is not expected. You cannot take these matters so lightly. This is a 2015 matter.
Yes, matter is very urgent. Your
Then how can you make a mention before this court saying that you have not brought the file because you received a call from the respondent side?
Supposed to take adjournment.
Whether the court is going to grant adjournment or not is the discretion of the court. Otherwise, what is the use of us taking these matters? You all can decide on your own on telephone calls and not come to the court. That is not the protocol of the court.
Short date, my lord.
Who is appearing for ASTC? It is very unfortunate that the old matters are ignored totally by the councils. It is very unfortunate. And unless there is a cooperation from the bar, it is very difficult for us to proceed also. 2015 matter. ASTC has filed their affidavit or not?
They filed affidavit, my lord.
All the pleadings are completed.
Yes,
what is the case otherwise?
Regarding allotment of ticket counter at the premises.
What order have you challenged? The allotment?
Yes, they have, my lord, issued the allotment order on the same date. They have cancelled it, my lord.
So the date, the cancellation of the allotment order, allotment of the ticket booking counter is under challenge.
Yes, my lord.
On what ground this was cancelled?
My lord, without showing any ground, my lord. And my lord, the petitioner also deposited the amount, bank draft, my lord. They accepted
Where
the
is the
amount
affidavit?
also.
the main party is the ASTC. Their affidavit is there.
Appearing on behalf of the ASTC, the Learned Standing Council is on legs on some other court.
I think this matter can be disposed of with a direction that the respondent shall hear the petitioner and pass appropriate orders. Because the case of the petitioner is that the allotment was done and on the very same day it was cancelled. The reason of the ASTC is that this was done without any tender or anything. So be done as it may. Since admittedly it was done on the same day without any notice, so we will send it back to the authorities. You take a decision, but you take a decision after hearing the parties. In this manner, no one is going to be prejudiced. The only prejudice of the petitioner is that without giving them an opportunity, this was done. Correct? Very well. Item 23. Heard MS S.B. Chaudhary, Learned Counsel for the petitioner, stop. Also heard
G. Duggar.
MS D. G for Guwahati.
Yes.
G. Duggar, Learned Standing Counsel. Learned Standing Counsel.
Counsel, I'm on behalf of the
Learned Counsel appearing for respondent numbers. ASTC will be respondent numbers. Two, 3, 4 and 5. 1 to 5. 1 to 5. With bracket ASTC. Stop. Case of the petitioner by filing the writ petition, the petitioner is challenging the order dated 11/3/2015 issued by the Divisional Superintendent ASTC Paltan Bajar, whereby the allotment order issued on the same day, i.e. 11/3/15, in favor of the petitioner was cancelled. Stop. Next para. The facts of the case is that the respondent authority issued allotment order on 11/3/2015 and on the very same day cancelled the said allotment without communicating him to the petitioner. Further case of the petitioner that the respondent accepted an amount of rupees 20,000 as security deposit in advance for a period of 1 year on 13/3/2015 and allowed the petitioners to construct and run the ticket booking counter for small commercial vehicles till the dismantling on 30/9/2015 without giving any prior notice and or furnishing the order. Stop. Next paragraph. MS S.B. Chaudhary, Learned Counsel for the petitioner, submits that the allotment of the ticket counter was cancelled on the same day, i.e. the date of allotment, without affording any opportunity to the petitioner. And therefore the said cancellation order is totally illegal and arbitrary. Stop. Next para. The MSG Duggar Learned Council for ASTC, on the other hand, submits that the allotment that the petitioner was allotted with the counter temporarily without inviting any tender. Therefore, cancellation is valid. Stop. I have heard the submissions made at the bar and have perused the materials record. Stop. It appears that the grievance of the petitioner is that the cancellation order was not preceded by any notice or hearing whatsoever. Stop. That being so, this court is of the considered view that this writ petition can be disposed of with a direction to the respondent authorities to give an opportunity to the petitioner and after hearing the petitioner pass appropriate orders in the matter. Stop. A certified copy of this order be furnished to the respondent authorities. Stop. Needless to clarify, upon receiving the copy of the certified copy of the order, the respondent authority shall complete the exercise within the period of 1 month, months from thereof. Stop. With the aforesaid observation direction, this repression state is disposed of. And just started DDBO. Resultantly, the impugned cancellation order is kept in abeyance till then.
Presenting mistakenly to
I'm sorry, what?
Presenting item 27.
28 corridor file to deduct. What does the status report indicate?
That report indicates that they could fail to find out any clue of the missing boy, my lord. That is.
What is to be done?
Now
Repeatedly, the son of the petitioner is missing.
Yes.
2018.
Yes. Police making effort to find out whereabouts.
You have the up-to-date status. This is of this is February 24.
29th February. Yes.
29 February.
Yes.
You can have the up-to-date. Now it's April.
But they filed twice, my lord, the report.
But there may have been some development.
The same answer, my lord, that they failed.
If nothing comes, then this court will have to consider something else.
My lord.
As a last chance, we may have this matter in the first week of May. By then, you find out if any progress or anything has happened since February. Since February, if there has been any progress in the investigation.
Yes.
And what is the scope? You see, something has to come out, right? The petitioner's son is missing. That is an admitted position.
Yes.
One cannot just give up unless, of course, there is nothing. So, this status report is neither here, neither there.
Yes.
Only shows that they are trying. But doesn't indicate positive steps.
No.
You can indicate the same in your letter and find out. Have it in the month of May. List this.
Submitted an with the
That is on record?
Yes.
The up-to-date status report in connection with the Jalukbari PS case number 1768 public 2018 and case number 1510 of 2018 is of 29 February 2024, comma. Court is of the view that that the respondent authority authority shall place before this court on the next date as regards what steps they have taken thereafter in order to find the missing son of the petitioner who is missing since 2018. Stop. Let the respondent authorities file an affidavit indicating the steps taken in this regard and also indicate the status of the investigation so far. Stop. List in the month of May. Any date? Date of the deboratory, May. List on 14/5/2024. On top, you record the presence of all counsel. Mr. M. Haloy for respondent number and 8. Please give our respective appearance slip.
I am for the Insurance Regulatory Authority. My lord, we are the formal party.
Last time also no one appeared for the petitioner.
Possibly they have lost interest.
Dismiss it for default?
I think appropriately that order may be passed.
Otherwise for?
Some claim they have made against the insurance company, and we being the formal party, my lord, we cannot adjudicate that. Settlement.
It appears, none appears for the petitioner on call. Stop. Mr. C. Datta,
yes.
S. Datta, learned senior counsel for, assisted by M.S.S. Mushahari, learned counsel for the respondent number 2 is present. Stop. It appears that it appears that there were no representation for the petitioner on the last date, i.e. 23/11/2023, when the matter was called. Stop. The order dated 23/11/2023 produced hereunder for ready reference to DD board. In view of the fact that none appeared, in view of the fact that there was no representation, also when the matter was called, comma, this court is left with no other option, no other alternatives but to dismiss the writ petition for non-prosecution. Accordingly, the writ petition stands dismissed for default.
Obliged.
Ordered Sate ase. And to DD.
I please the Lordship. Petitioner are landless and landless and flood affected erosion.
It's all filed?
Yes, Lordship.
Yes.
According to our affidavit, we come to page 2. Page 2 of our affidavit, paragraph 4. Petitioners have encroached the VGR land Covered by DAG number
Affidavit 2
Affidavit
of respondent 3.
Respondent number 3.
Yes.
Page number 2. The 4.
Lordship, a matter is purely covered by our High Court judgment, Lordship.
Yes, paragraph. PGR land.
Yes.
Encroacher.
No, Lordship.
No question
Already subdivisional land advisory.
You are relying on section 6.1 of the land policy.
Land policy. This is land. This affidavit is filed on 2017. Now new land policy has come.
But in this case, which one will be applicable?
In 2019 will be applicable.
2019. So as per that, any change?
I have to verify.
Because you see, according to you, the stand taken by you is that the land of the petitioner is a VGR land, and the petitioner is an encroacher, and in terms of section 6.1 of land policy 1989, petitioner is not entitled to get the settlement of VGR
yes.
land. That is your specific stand?
According to new policy also it is, it has...
There are those provisions that there cannot be any allotment in case of VGR land.
Yes.
Where is that provision? Show me that provision. And what is this decision that you are trying to rely?
Lordship 2023-1 GLT 452.
Yes, I have it before me. What do you want to show from this decision, Mr. Counsel?
If there is a VGR land, that is why Lordship also...
There can be a paragraph. Paragraph.
Okay.
Counsels, you all are relying. If you rely upon a decision of the court, you must know which
Lordship
paragraph.
18, Lordship 18.
Paragraph?
18, Lordship.
Here the settlement is of which year?
Lordship, actually Land Advisory Committee approved the land in favor of the petitioner, Lordship, page 13, Lordship, Annexure C, Lordship, read petition, Lordship.
So in this 2023 case, this land policy is which one? The same land policy?
Actually,
yes.
It was recommended 1989 policy, Lordship.
As per 89 policy?
Yes, Lord.
Recommendation.
Belongs to ST community, Lordship.
In your case, recommendation was made when?
Made, Lordship, 18/10/2010, Lordship.
1810?
Yes, Lordship.
2007?
10/10, Lordship.
2010.
Yes, Lordship.
Which page?
Page, Lordship, 13, Annexure C, Lordship.
By the DC?
The minutes of the SDCL, Lordship. It is not CL number Lordship 19, Lordship. Indranath Dole, Lordship. 91, Lordship Rajan Dole.
Page, where is the recommendation page?
Lordship, page 13, type copy, Lordship. Annexure C, Lordship.
There is already a recommended settlement proposal in your favor.
Yes, Lord.
And after that, what happened?
After that, the respondent already have not taken any needful action.
No steps have been taken. Yes.
Yes, sir.
Your affidavit is not very specific. There is no bar for settlement in favor of a VGR land. Rule 95A is there. Settlement.
Come to paragraph 6, Lordship.
Rule 95A is applicable or not? Counsel, you are not clear with the facts. How will you assess the court?
Lordship,
The whole matter. Paragraph?
Paragraph 6 of our affidavit, Lordship. That in regard to the statement made in paragraph 6 and 7 of the writ petition, the deponent states that it is
It's not been approved till now. Why has it been not approved? That is the precise question of this court. Where is the bar?
VGR land, so.
No, where is the bar? You show me. Where is the bar? Simply saying it in your affidavit will not do. Where is the bar? Where is the provision which bars the settlement of a VGR land? Where is that bar? Counsel, you are a government counsel. You cannot simply rely on the affidavit and present your case. You have to apply your mind to the averments made in the affidavit, correct? Where is the bar? Where is the policy? Please show me.
Policy.
Show me from the policy where there is a bar for settlement of a VGR land. This court has already given an order where this court has said that there is no bar. Have you seen this decision or not? Sarkar Najrul Islam.
I have not been.
If you are not prepared, then how will you do cases?
Kindly give further time.
This is not done, Ms. Counsel. This matter is listed for hearing. It's a 2017 matter. Please be ready with the hearing.
Yes, Lordship, our affidavit also not clear. The now 2019 policy.
This matter you post it on Thursday. Thursday. You be prepared.
Yes, sir.
No further adjournment is going to give in to you.
Yes.
You said the petitioner has heard the petitioner. Stop. However, the government counsel MS
S.
Borwa was not prepared to present the case. Hence, today's time has been granted. Stop. List on Thursday for further. You be prepared and give the government counsel a copy of that order of this court.
It's from NC Hills, my lord.
Yes.
This is for hearing.
Standing counsel NC Hills.
And she will be required. And I am standing counsel for NACI.
Basically, we are against the NACI, my lord.
What is your case?
Case is, my lord.
Without compensation.
Not land compensation, actually. They have damaged our land.
Without compensation.
No.
No. There is here, my lordship, due permission, because what I am understanding, because NACI, because we have constructed a road after following due procedure. Whatever land is acquired, day after construction is going on. According to my petitioner's who have my understanding, because subject to his satisfaction, and then while construction, that is a ROW, that is mean right of way. What we do we take that is called this from center to 100 feet, suppose that is right of way. Now, according to him, got damaged beyond ROW. Which land was not acquired by us, but contractor has damaged the
Then how are they entitled for compensation?
Yes, there I am. Then I have filed affidavit to that effect that because beyond ROW we do not have provision under the provision of contract agreement.
That is the understanding of the court also. If your land was
filed
not
affidavit
acquired
also.
and some damage has been caused, you may have some remedy under the
Yes,
civil.
definitely remedy is there. He is supposed to get it, but not by that issue. Because already I have filed affidavit in 2018.
Where is the affidavit?
Affidavit, my lord. Lordship will get it. One Karge Committee filed on 16/2/2018.
Before that,
1 second, I'll come back to you.
I'll come back. I'll make clear day after you.
Affidavit is?
Affidavit filed by one Mr. Karge Kamki on 16/2/2018.
The affidavit of
17, maybe 16,
Is it respondent
maybe
number
17, my
six?
lord, maybe.
Is it respondent number 6?
yes, my
Yes, my lord. There's a Karge Kamki one. Respondent number 6, my lord.
Yes.
Here, a very short affidavit we have filed. Here, lordship will get it, para 5, my lord. First, second, third. By fifth, we have clearly stated, my lordship.
Beyond right of way.
Yes, beyond right of way, there is a provision if the damage as per our contract agreement is there, my lord. As per contract agreement clause, that is, I have annexed, my lord, as a page 5.
If there is some damage beyond the right of way, it would be the contractor who shall be responsible.
Contractor has to pay.
That was an admitted position?
Contractor is under damage.
I am not asking about that. I am asking, is it an admitted position that the land is beyond the right of way? That much is admitted?
That much is
admitted, correct?
Revenue affidavit.
That is admitted?
There is an inquiry report, madam.
Where is that inquiry report?
I am coming to, madam. Respondent 4, madam. Affidavit in opposition. From here, my case started.
Part 4?
Yes.
Page 57.
Lordship, 1 minute as before this. What happened now? Because if your lordship is disposed of, he may be affected or I may be affected, because just now morning I discussed with them, because it was in part 2 list actually, my lord. Now morning, evening.
There is urgency in this.
No. Oh, I'm not telling on that. No, that is why morning only I could collect this information. There is a similar this one beyond right of way, some damage was caused to, like similar this one is there. Government has written to, they are taking some initiative, constituting one damage committee to find out the real. Because by lordship this one.
Case of the petitioner?
Petitioner also maybe, because here we cannot say anything. Lordship schedule is not there. Only village name is there. One Kashera village. Even schedule is not there, my lord. There is a big village, your lordship, and you know, lordship know. Area is very big. How we can identify by village? Village one side we may not do. But anyhow, not on that. If your lordship, for ends of justice, let it be fixed Thursday. I got all information, my lord, by WhatsApp, because I could not get print out some print out difficulties. Lordship. And it will be, no, if he wants disposal, right, I can do it.
Okay, Mr. Bora, we've heard you.
Yes.
1 second. Yes, inquiry report. What you wanted to show?
What I am saying, from this inquiry report, Annexure 3, my lord. Internal page 6, my lord.
Page?
6. Annexure 3. Inquiry report filed by the revenue.
Yes.
The lordship will see that from serial number 1, 2, 3, 4, 5, 6, 7, up to 13, my lord. They have done the
Beyond
inquiry.
ROW.
Yes. Now,
inquiry is beyond ROW.
They were also asked to be participate. But
very well, we'll have it on Thursday. In the meantime, let Mr.
If some progress is carried out, it will be better for him, my lord.
Says that he has received some
instructions.
Yes,
lot of information I could not print out.
Very well.
Thursday.
As prayed for by Mr. C. Borwa, Learned Counsel, for respondent number
6, my lord.
6. For respondent number 6, list this matter again on Thursday.
My case basically is, my lord, on
C. Borwa, Learned Counsel, for respondent number 6, admits that he has received information that a damage committee has been constituted in order to ascertain the damages caused to the lands of individual which stands beyond the ROW stop.
Yes.
He accordingly seeks some time to place the same before this
If
court stop.
required, by way, try to give by way affidavit. Otherwise, by not.
When do you want? Monday?
No, Monday, because Monday, next Monday,
Yes.
Lordship want to say next Monday.
This week there is no Monday, Mr. Borwa. Next
Sorry,
Monday.
sorry. No, this Thursday.
How much time do you want, Mr. Borwa? Please, judicial
Tuesday,
time is
Tuesday.
being taken.
Appeal to Tuesday ki day?
Not
Oh, not it. 9th, my lord.
9 April 2024.
I'll try to have affidavit, my lord, to the extent.
Is the same by way of an affidavit.
Yes, my lord.
For hearing, my lord.
Hearing, my lord.
Already there in hearing.
Today you will be, you will be lost. Today I'll tell you, lordship.
Yes, next matter.
Oblige, my lord.
6.
I'm sorry, my lord.
No problem. Yes, Mr. Datta.
Yes.
Petition?
One incident took place in the factory premises of the Hindustan Unilever Limited, having a factory at Dunduma, Rupai side, cosmetic factory. On 6/7/2007, there was a discussion between the management and the employees union. It starts from noon to 2 p.m. But the situation aggravated, and 17 officials of the Hindustan Unilever Limited was confined in a room for 16 hours.
Confined in a room?
By the union leaders. And it starts from 2 p.m. on 6th and continues to on the next morning. On 7th, they were rescued from the room. One lady officers was there. They were not allowed to, in fact, prohibiting from taking nature's call. AC was put off. So, inhuman situation in that.
You are for the management.
I am for the management. So
there was a reference.
Thereafter, FIR was lost.
There was a reference.
There was a reference.
And you are challenging the award.
No.
In this
we
petition?
are on the preliminary issue of validity of domestic inquiry.
So, you had raised the preliminary issue before the
Tribunal. Absolutely.
Labour
correct.
Court,
Yes.
and the Labour Court held it against the management.
Against them.
The Labour Court has held that the inquiry was valid, all the procedures have been followed. Natural justice and everything.
The Labour Court hold that the inquiry was not valid. The due opportunity was not provided on the 3 counts. I will come to that.
Also, the Labour Court held that the inquiry was not valid.
Valid.
Against that, now you have come.
Yes.
But there is one judgment of Justice Ujjal Bhuya.
Pratapgarh Teesta, we were in other side, Milord.
That is right.
That followed Ludbut Singh since Milord.
No, it followed that which is that case Supreme
Delhi
Court.
Cloth House. Delhi Cloth and General Mills Company. Munad Goyal.
You have that case?
Yes, Milord. So that judgment is not with me, Milord, but they
have that judgment.
They are allowed to reduce their evidence on merit. So, Milord, there is
not on that. You see, one sentence in that Supreme Court decision, which says for whatever worth the preliminary inquiry was held not valid, whatever word that it be, that should not be challenged by way of writ during the interval time. When the final order is passed, along with that,
yes,
that can
Milord.
come.
It is from
There is a decision, and Justice Bhuya has. In fact, I had appeared in that.
We were in
that
other
is
side,
why
in Pratapgarh
I
Teesta.
remember.
Unfortunately, I am not.
Kindly have that because
No,
it's a
that
coordinate
Ludbut Singh was
bench
followed,
judgment, and it relied on that that old case 68.
172 was there, Milord. The Delhi Cloth and General Mills. That
Not
was
Delhi
followed.
Cloth, another one.
Then
before Delhi
Firestone.
Cloth.
Firestone tires.
Firestone.
Delhi.
It relied
yes,
on
Milord.
Firestone.
Firestone. Then the.
Show me Firestone.
Yes, Milord. Firestone is here.
Just 1 second. Because you are on that, we will
Yes,
hear
Milord.
you, Mr. Datta.
Both of us are
Don't get
being
anxious.
granted
We will
liberty to
surely
reduce
hear you.
evidence on merit, Milord.
All on the deliberation.
But since the matter pertains to a preliminary award, that is why.
Not award, Your Lordship.
Preliminary order.
It is paragraph 32(4), Milord.
Because the is very well settled. Whenever the management has the discretion to rely on the preliminary inquiry that they have held or not to rely. In a case where you want to rely, then the Labour Code will issue a preliminary, will formulate a preliminary issue as regards the validity of the inquiry.
Correct.
Now that has been done in your case, and it has been held that the inquiry is not valid. Now you can always adduce evidence, and the entire matter is at large.
There is a caveat.
Is granted, my lord.
No,
In order, that liberty is granted.
What is the caveat?
Caveat is that in other judgment, lordship compilation, that there is the Supreme Court has settled the procedure. The
Yes,
first
enlighten us, because as far as this court is aware that if you ask, that liberty will always be given
Liberty
to
is
you.
given,
You have
Lord.
a
Page
right to adduce
272.
evidence.
No, I'm not
Page
on that.
272 of the writ petition,
We are
liberty is
not on
given.
that point. The first procedure is that the Labour Court has to frame the preliminary issue whether the validity of it. Now, if the validity is, if the Labour Court holds that the domestic inquiry is valid, then the Labour Court has to go to section 11A for determination of, to appreciate the question of the determination of the punishment.
You may say to go, it is
Yes.
the moment, you see, the moment the Labour Court comes to finding it is not valid, it is for the management and for the labor, for the workmen
to adduce
evidence if they want, on merit. Suo moto, the court will not go into all that. It is only when asked. It can be asked by at the very time when they had filed, or it can be asked at the time when this issue was decided.
Yes, that is in Munad Goel.
One second. Let the senior counsel speak. You can take your seat.
Oh, the question is, Your Lordship, that if your Lordship finds that there is a perversity in the findings in the Labour Court's order, so far the question of the validity or invalidity in question, then Lordship has to, Lordship may intervene in the matter. Now, in the order, Lordship will find prima facie.
Perversity, I think, is 68 Supreme Court writs motors.
Yes, absolutely. Now the Lordship is aware that there is a leading judgment on the issue of the domestic inquiry, how it is to be a sure animal case. So the tribunal exceeded its jurisdiction by overlooking all settled position of the Supreme Court in respect of the question of the validity of the inquiry. He is travelled beyond the purview of the parameter as fixed by the Supreme Court. Therefore, we are before this Honourable Court. If the tribunal examine the veracity of the domestic inquiry on the parameters of the sure animal case, we have no case before the Lordship. Lordship will see that the impugned order we challenge before this Honourable Court, even not touched, even not discussed the sure animal case.
All right, let us see the facts now.
Yes, Lord. Lordship kindly comes to the first what I proposed, that Lordship may kindly have a look at sure animal case first, and to examine the entire matter on whether the domestic inquiry has performed these under the parameters of the sure animal case. So she will get it in para 4, case 2.
Sure animal.
The first case I have relied. Compilation first.
Yes, I have got it.
Yes. Now, yes.
Which paragraph do you
para
want
4. The last few lines.
Just 1 second.
Lordship.
Yes, you want to rely which paragraph?
Paragraph 4, my lord.
Paragraph 4.
Last part.
Yes, please.
Last part, it starts from an inquiry.
An inquiry cannot be said.
Yes.
Yes.
An inquiry cannot be said to have been properly held unless, number 1, the employees proceeded against has been informed clearly the charges level against him. number one. Second is the witnesses are examined ordinarily in the presence of the employee in respect of the charges. Third is the employee is given a fair opportunity to cross-examine witnesses. Four, he is given a fair opportunity to examine witnesses, including himself in his defense, if he so wishes on any relevant matter. And fifth and last is the inquiry officer records his finding witnesses. Now these 5 parameters, Lordship,
as whether an inquiry is validly, properly held or not.
Yes.
Right.
So these
number 1, clearly informed. Number 2, all witnesses examine in presence of the, and then opportunity to cross-examine and opportunity to examine witnesses, including himself, and record findings with reasons.
Yes. Now the inquiry starts on 5th 11/2009.
In your case?
Yes. 2007.
5/11/2007.
Inquiry. And is concluded on 10/10/2009.
10/10/2009.
Yes.
So many.
48 sitting. 48 sitting.
48 sitting.
Yes, Lordship. And admitted position.
Why did the Labour Court held this inquiry not valid?
That's the very funny thing. I must say it's a funny thing by the Labour Court. Because the Labour Court not go into that matter, whether the charges were explained, whether the examination
all opportunities given,
or the witnesses were examined in presence of the employees.
Then on what ground?
Now, Lordship, kindly one fact, Lordship, kindly have a look. The examination of the 5 witnesses of the management witnesses, all of them cross-examined, and cross-examined altogether 371 questions were asked.
Yes.
371 questions were asked on behalf of the, and 13 workmen were examined.
Yes.
So therefore, to appreciate my submission, Lordship, may have a kindly look at the examination and cross-examination part of the workman witness number 1.
Just simply, can you first just indicate on what ground the inquiry was held? Then we'll come back to how you want to substantiate.
Lordship, there's the four grounds.
Yes.
4 grounds.
Page.
The inquiry officer.
Where is that order?
The workman and the inquiry officer who will.
Board itself is.
Yes. That is the how. 37. 237, Lordship. Copper engineer. Second
237 or 235? Scrutinize the evidence.
I'm relying.
35 is proceeding.
237 starts from
internal
a
page,
meeting.
Internal page
Internal
23.
page 33.
Right, there is some difference.
The last annexures.
Starts with a meeting was held on
266. Starts.
Yes. Court has now.
L ordered at a copy 44.
That order.
I'm marking 240. Relevant is.
Meeting was held.
Meeting was held. 266.
Put in is the copy of procedure. The report of the inquiry officer. Showing the various orders sheet thus contains a running record and representation of both the parties. Thus the daily order sheet should orders of the inquiry authority. Officer, the
order sheet is not
through lawyers.
Where?
It is 2 in 25.
Here's with the pages.
First paragraph.
Yes, it appears from the proceeding.
To defend their charges leveling, considering the submission of the parties opportunity. In the absence of any, so far as the fact situation circumstances do not warrant, 11/2007 by workman, this petition also rejected by the inquiry officer opined in his order the knock of law and order in the factory premises should come, and the domestic inquiry is that there would be an outbreak of chaos and ending. He permitted the managing officer from time to time, or any such and such. Conduct may not be graduate. they are workmen is so serious as to entail permitting the employee to engage in legal practice in hand, considering this.
According to the workman side, to be represented by a lawyer on grounds on which there is not maintainable. These are the three grounds till now.
It is seen on the for allowing them to represent again.
Not a the company. This company is. It's not applicable.
That is applicable.
That is applicable.
2 is other established.
Now, standing.
There are 3 judgments of the Supreme Court, which and the Lordship will find internal page 30. In the initial stage of proceeding, the inquiry officer agreed to record the management witness's mother tongue. He also attended by the management for the proceeding as per the specific order passed by the inquiry officer.
Translator, 1 second. Not disclosed. Translator appointed by the
8. Some words have been written in bold letters.
I mean, I have not understood. What is
to say? In the charge sheet, some words and to say that
these none of it on the face
that's
of
the
it.
Point, Lordship. That's
presented by a lawyer.
Yes.
That is not required. But what
unless there is a rules.
In that case, yes.
That is dated before the law.
It prima facie appears.
The 2 paragraphs in the
head notes.
$75 to SCC 661. $75 to SCC 661.
1 second. 1976
61. 661. The author by Justice P.K. Ghoshal. By an employee is found by a labor court as a violating.
We are therefore
of an employee inquiry has violated the principle. There will be no difficulty. But in an issue on that dues any evidence before the labor court, make it clear that there will be no justice. Yes.
That
no justice when the matter.
If a coordinate bench of this court. But the same you can always have it after the judgment. We can have this matter, but you have this court submitted what you are submitting today. So, judgment in Patapgarh in that case. Have a look at that.
And merit
36
of the industry.
Recognized union.
36 is different respect.
And 36 says a workman who is a party to a dispute is a member. There of a federation of trade union by any member in the industry in which union leadership it is permissible. That domestic inquiry.
Because if you read submit, Mr. Datta, you please take.
Labor Court, Tribunal, National Tribunal. But what?
Through them, there the.
I am on. But regarding fairness of domestic inquiries.
It's a different aspect. The petition is maintainable when the final parties are at large to adduce fresh evidence, Cooper Engineering and Patapgarh's case.
I'm giving it. We fix on day after tomorrow, then Munad Goel has been held to be correct.
Evidence after inquiry.
After, and what I did not even requested for adducing evidence. Cooper Engineering has been relied at page 30, relied in paragraph 21 and 22
Council,
of the.
We on that. We are not on that.
No. All the procedures have been laid down.
That procedure inclusive list on further hearing on.
It is Wednesday. Occasion it was.
Lordship has completed the list.
Got note on it. But Mr. Datta, please. Is reading the relevant portion. It is abundantly clear from the above reading of the said provision that in order to reassess under section 40 of the Act 2003, there has to be firstly an assessment in law. In the present case, there was no assessment under section 35 of the Act 2003 made during the prescribed period. Therefore, no assessment can be deemed to have been made in law. In view of the above, the said order of reassessment having been completed without any assessment having been made under section 35 of the Act 2003, the order of reassessment dated 17/3/2000 absolutely illegal and without jurisdiction. As such, the very initiation of the proceedings under Section 40 of the Act 2003 is absolutely illegal, without jurisdiction, and not tenable in law. Accordingly, the impugned order of reassessment dated so-and-so and the notice of demand dated so-and-so are set aside and quashed. The present writ petition stands allowed and disposed of.
Taken up after view. It may be fake.
You had asked to keep this matter at 2 o'clock. At your request, this matter was kept at 2.
Thanks, my lord. I have prayed for adjournment.
Ms. Gogoi, first of all, this is a court. Please be mindful where you are standing and what you are submitting. It is very important. Protocols running. Take it seriously. You are seeking for time and you are laughing. It is not the way you make submissions. Please be conscious of your conduct. Why do you want accommodation today? It's a 2015 matter. You are competent to argue. You are competent counsel. Why do you want time?
I'll go to argue the matter.
You are there on record. I see your name.
Yes.
What is this matter?
Pertains to commodity taxation under the Assam Entry Tax Act 2008, my lord. Phrase is, my lord.
Commodity tax.
Commodity taxation under the Assam Entry Tax, my lord.
Yes. What is the issue?
Whether the item which the petitioner is in the business of manufacturing of pate raisins and PP granules, for which the raw materials.
Manufacture of?
Pate raisins and PP granules, for which manufacture the raw materials are to be procured from the outside the state of Assam, my lord. And for that, the respondents have given. They have said that it falls under chemicals, under the entry or the
falls under chemicals, under the entry chemicals.
Yes, my lord.
Yes.
And they have levied entry tax
chemical
on that.
Now, according to you, entry tax is not leviable. There is an exemption.
There is an exemption, my lord. There are several judgments by the Supreme Court as well as Guwahati High Court, but it is not clear whether it is not clear. User taste and common parlance taste is the most important criteria.
Here, my lord, so far as the after the assessment, my lord, they approached the Honorable Court. The Honorable Court there said that, my lord, it will
this assessment is under?
It's under the Assam Entry Tax Act 2008, my lord. The entry is 51. There, my lord, it has been mentioned as chemical. But my lord, the item herein is, my lord, it's PET resin. PET, 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 RESIN, resin. Whether it will come under the, my lord, ambit of chemical.
Entry 51 or not. If it falls under entry 51, then it is taxable.
Yes. Now whether according it can be brought under the ambit of
according to them, it is not It is not taxable because it does not fall under entry 51.
Yes.
That is their case.
Yes.
Now, how have you made your assessment? Have you gone into that?
Lord, yes. So far as, my lord, our
and
assessment
what is the ambit of and jurisdiction of this court? Because
they have, my lord, alternative remedy they have exhausted. They preferred appeal, yes. Appeal, thereafter revision, thereafter this Honorable Court.
So here, what is under challenge? The appellate revisional orders?
Both
the
assessment, appellate order as well as the revision order.
Where is that order?
If Lordship takes up, my lord, item number 15.
Item number?
15, my lord.
15?
Yes. 5647/2015. But there we have filed a detailed affidavit which we will rely.
All right.
Otherwise, my lord, the assessment orders are different, but issue remains the same. Commodity.
Let us see.
Here, my lord, page 47, if your lordship may kindly see.
Page 47?
Yes.
Yes.
This is the order, my lord, passed by the division bench of this honorable court. It was passed in 2012. Para 2, Lordship may kindly see. This petition seeks passing of orders dated 8/12/2009 and 6/5/2010 issued by the Commissioner of Taxes Assam, Guwahati, under Section 105 of the Assam Railway Tax Act 2003.
Yes.
Regarding taxability of PV granules and PV resins. These are the two items, my lord.
Yes.
By treating the same as being covered by entry 51 of the schedule.
This order is of whose? Division bench. In another case.
Tax matters were taken up by
in
the
another case.
In another case.
In another.
Yes.
Similar case.
Yes. Under entry 51 of the schedule to the Assam Entry Tax Act 2008. That is chemicals.
Yes.
The case of the petitioner is that they are manufacturing PVC pipes, fittings, casting pipes, etc. by using PVC granules and PVC resins, apart from other raw materials. The raw material is brought to the state of Assam from outside, thereby attracting the provision of Entry Tax Act. Under the said Act, the schedule of taxable items includes chemicals under Entry 51. According to the petitioner, the said expression did not cover the raw material items imported by the petitioners mentioned above. The issue came up for clarification under Section 105 of the Act, and it was held that PVC granules and PVC resins
are chemicals.
Were covered by the expression chemicals. So they, under Section 105 of the VAT Act, the authority is given to the Commissioner of Taxes to clarify in case of there is any doubt. So he clarified that.
Now, entry 51 says chemical.
Yes, only chemical.
Chemical.
If we consider it broadly.
So in this case also, therefore, one of the issue is whether this PVC granules and PVC resin are chemicals or not. Now this issue, according to you, has already been...
No. But here, my lord, Honorable Court said that, my lord, there are certain, my lord, loopholes in this particular clarification. So Honorable Court said that, my lord, it will be decided in the appropriate litigation.
Has it been decided?
No, this will be the, my lord, case now, my lord, to decide on that one. Here, my lord, that theory of common parlance and, my lord, user's taste and all will have to be applied. Because, my lord, we have checked, my lord, I have, my lord, checked, my lord, on this issue, my lord, there is no judgment. At least on these particular two items.
So if you apply the common parlance, test of common parlance, then according to you...
My lord, as per assessment orders and all, it will be, my lord, chemical. Broadly, if we see, my lord.
Who are carrying those decisions?
My lord, so far as the...
Because that is your case in short.
Yes.
According to you, it is by applying the test of common parlance...
or users.
In this case also, Ms. Gogoi, it is both PVC granules and PVC resins.
Yes, ma'am.
So that is the case of the department.
Yes.
And the assessment, the appellate authorities orders...
Orders are detailed, my lord, if lots.
Have they applied the test of common parlance?
My lord,
how have
we
they
have
determined...
relied upon one judgment of the, my lord, Gujarat High Court.
Gogoi, what this court wants to know is, on what basis they said that is entry 51?
It is their case that it will have to be, my lord, considered as per the common parlance, and we'll have to see, my lord, how...
I'm not asking about their case. Before authority, appellate authority...
My lord.
There must be some findings to that effect?
Yes, my lord, yes.
On what basis they have held it
they
to be
relied upon the judgment of the, my lord, Gujarat High Court.
Which part of the
order? Lordship will find that at page 54, this is part of the appellate order, page 52 starts.
Yes.
Lordship will find that, my lord, in page 54, the last part, heard the learned counsels and considering her entire submission, it is true that plastic granules are not found or sold in chemical soaps, but it is also true that the said goods are not found in general soaps.
Where are you reading?
Page 54. Last part, my lord, last para.
Okay.
After the submission, my lord, this is the order.
Yes.
Heard the learned counsel and considering her entire submission, it is true that plastic granules are not found or sold in chemical soaps, but it is also true that the said goods are not found in general soaps. It is manufactured through chemical process and also being used in a chemical process. The learned counsel could not refer to any instance or rulings in which these goods have been decided as non-chemicals. It is found that the relevant entry of entry tax schedule reads chemicals. the usage of the word in plural number clearly indicates that the legislative intention was to consider the description in the same wide term as it is understood by the trade industry in general.
Prima facie, it appears to be chemicals.
Yes, my lord. So, next page, my lord, Lordship will see the Honorable Gujarat High Court in the case Quality Chemicals versus State of Gujarat, reported in 1994 STC 450 Gujarat, ruled that Malik resins
Is there an interim stay order operating in these cases?
my lord, so far as the no coercive action probably is there, because the, my lord, after that we will be issuing the demand notice. So that part. But my lord, this whatever will be the outcome, it will have a, my lord, pan-India effect, my lord, because nobody has, my lord, adjudicated on this particular issue. At least this item, my lord. Here, Lordship will see, my lord, before the Gujarat High Court, the item was, my lord, in the my lord, second line of page 55, ruled that malic resins, which are synthetic resins containing ester gum, fumers and esters, so and so.
Where have you? Where do we get the definition of the products involved in this case?
My lord,
is it been detailed out in anywhere in the petition or
62, my lord.
order?
The petitioner, my lord, probably, my lord, from downloading from the, my lord, internet, has placed this. But, my lord, from this, my lord, whether it's a chemical or not, that probably. Polyethylene.
How can this court
my lord, yes,
enter
of
into
course,
this
my lord,
area?
some, my lord, expertise will have to be there to decide. Some opinion, my lord. In my lord,
but you see, here, as far as this court is concerned, this court has the advantage of the orders of the assessing authority, appellate authority, and the revisional authority. Now, the order at the page 54 is part of the appellate authority order.
Yes.
Now, there the court has already taken into account that plastic granules are not found or sold in chemical shops, but it is also true that the said goods are not found in general shops.
Yes.
Is manufactured through chemical process.
Yes, ma'am.
And also being used in a chemical process. The Learned Counsel refer any instance of ruling so and so. It is found that relevant entry chemicals, the uses of the word in plural number indicates this is which. Now, because the chemical process is involved.
It will be termed as a chemical. Well, that's why, my lord, it's instead of chemical, the entry is chemicals. It will have a wider, my lord, connotation. Well. And
at page 57, this is the revisional order?
yes, my lord. That is in fact more elaborated, my lord.
Yes, I've just seen. Yes. Read 57 second para. It appears that
adjudication of all the four present revision petition depends solely upon the resolution whether the item PET resin is covered by entry serial number 51 of the Assam Entry Tax Act schedule reading as chemicals. It has also been judicially settled by the decision of the Honorable Court in 3344 of 2011 and 7 others. Similarly, read petitions that whether the expression chemicals will include PVC granules, PVC resin and other raw materials utilized in manufacturing products like plastic pipes or buckets, polythene sheets, plastic bottles or jars, including those suitable even for packaging foods, drinks, etc., is primarily a question of fact, and therefore the same needs to be decided as such without converting it into a issue of law. That was, my lord, observed by the division bench.
Yes.
Now the petitioner seems to have cited following relevant pleas in recorded grounds of revision. That the item PET resin is not considered as chemicals in common or commercial parlance. That the observation of the learned Deputy Commissioner of Taxes Appeals, namely, even though PET resin is not found in chemical soaps, it is also not found in general soaps, cannot be regarded as a common parlance test for determining whether the term PET resin is chemical or not. That the Central Excise Schedule enumerates chemicals under one heading, while polymers including PET resins have been enumerated under a separate heading. Further, since the Central Excise Tariff Schedule, while enumerating chemicals, has not included PET resin and other polymers, the latter cannot be regarded as chemicals.
Come to paragraph 2.
Para 2.
Page 59.
Regarding this part, my lord, one thing I would like to point out, Roman 3 of my lord,
page 58.
Page 58. Regarding this, my lord, Roman 3, regarding this Central Excise Tariff Schedule, where from they wanted to borrow a particular provision, Honorable Division Bench held that, my lord, in separate statute, the items will be different. It cannot be that, my lord, in this particular Central Excise Tariff Schedule, if a particular item is there, my lord, as chemical, and if it is not mentioned in our, my lord, Assam Anti-Tax Act, it cannot be, my lord, that inference cannot be drawn.
That it is a chemical?
Yes, Lordship may kindly have.
So what inference? That it is not chemical or it is chemical?
It's not chemical.
Simply because it is not there?
Yes. My lord, page 49 for a moment, my lord, because they will be, my lord, harping on this particular point.
Sadly, they are not harping on anything.
No, not harping, my lord. They may refer to this point, my lord. 49, my lord. Para 10.
49?
Yes, 49. It's part of the, my lord, order passed by the Division Bench in 2012.
Yes.
Para 10. Since the question whether the expression chemicals will include PVC granule and PVC resin is primarily a question of fact, without expressing any opinion on merits on the contention raised on behalf of the petitioner, we consider it appropriate to direct the same. Oh, my lord, I'm sorry. Para 6. Sorry, my lord. The previous page. 48. Learned counsel for the petitioner submit that section 2.2 of the Act, all expressions not defined under the Act will have the same meaning as in Assam Value-Added Tax Act 2003, and therefore expression chemical should be treated as per definition in the Assam Value-Added Tax Act. This contention cannot be accepted. Entry in the schedule is not an expression used under the Act which may call for interpretation. Entry in the schedule has to be interpreted as per established principle for interpretation of the same and are not normally subject matter of definition clause in any act. In this, it is next submitted that under the Central Excise Tariff Act 1985, plastic material was not treated as chemicals. This contention can also not be accepted. Under the different taxing statutes, there can be different schemes of taxing some goods. The fact that plastic material was not chemical under the Central Excise Act cannot be ground to follow the same pattern in the present.
But in that case, how will you apply the test of common parlance, Mr. Gogoi? Because here, the question is whether the subject falls under chemical or not.
Awesome.
Now, in some statute, it has held to be chemical. It has fallen.
Yes.
Now, if that has been shown as chemical in relation to another statute, then in parlance we can accept that. Can we not?
No, so far as the statute part is concerned, because in some particular statute, say my lord, the entry tax may not be applicable, whereas my lord, VAT or my lord, GST may be applicable. So that part, my lord, because my lord, they have been referring to this particular act, my lord, of Central Act, that is my lord, Central Tariff.
Yes.
Now my lord, para 2.
In all the items, the same product.
Para 2, my lord. The Honorable Gujarat High Court in Quality Chemicals versus State of Gujarat, 1994, 94 STC 450, ruled that maline resin, which are synthetic resins containing ester gum, so and so.
Before the Gujarat High Court, it was which statute? VAT.
No, my lord. The statute was.
Just read from the appellate.
Yes, ma'am. No, that my lord act is not mentioned.
Can you
but
ask your junior to find out?
Yes, yes, I can.
That citation is available at page 55, 1994, 94 STC 450.
No, STC, not STC.
STC.
Yes, but I have a copy.
You have a copy?
Yes, yes.
What is the statute?
My lord. Central Excise Tariff. It's my lord Central Excise Act. Central Excise Act of 1944.
Here it has been
held that my lord.
They are chemical.
Chemicals.
They are chemical.
Yes.
Yes.
The Honorable Gujarat High Court in Quality Chemicals versus State of Gujarat reported in 1994, Volume 94 STC 450 ruled that malic resin, which are synthetic resins containing so and so, obtained by chemical process were chemicals under similar factual matrix as the present one.
So the idea is how it is done.
Yes.
If a chemical process is used, then it is said to be chemical.
It will be a chemical matter. Now,
here that part is not available, that how these subject products are made. Is it available on record?
On record, my lord, they are supposed to, my lord, establish the case that this is not a chemical.
That's right, but
they have, my lord,
you are assessing
my
it
lord,
to be as chemical.
Yes.
So there must be something before you also
My lord.
to show that they are chemicals. Otherwise, that is the only thing.
Yes,
if
my
a
lord.
chemical process is
Yes,
involved.
Yes.
But how will this court come to that conclusion? There, some literature, nothing has been placed before. Maybe in these orders, you read, just finish this part, maybe something comes out from here. Now in the use
description for commodity PET resin, the full form of PET is polyethylene terephthalate. On the other hand, numerous synthetic varieties like nitrates,
so and so
of naturally occurring resinous substance like so and so were obtained and produced during the 20th century, bringing in a dramatic growth in the chemical industry. Numerous other chemical varieties of resins have proliferated during the recent years. Such resins as so and so have become available in the market. They all offer specific quantities as films, plastics.
Therefore, chemical process is involved.
Otherwise, well, it's involved. In fact, relying heavily.
Gogoi, you are saying it is chemical, or you are saying it is not chemical? I am getting confused now.
You are saying it's chemical. That will be. That's why it will be under my lord entry 51 and my lord it's leviable. My entry tax is leviable. My lord, next, my lord, last second line is important, my lord. Marketers, manufacturers, and trade organizations divide chemical industry products into three categories. A is the basic chemical, the relatively simple chemical products used to formulate more complex chemicals. B is the intermediate chemicals. Well, intermediate chemicals are the raw materials. Well,
intermediate chemicals,
yes,
such as plastic materials,
fiber. Intermediate as plastic materials, fiber chemicals, and other materials used in manufacturing.
Said to be which one?
Manufacturing and products of various types. C is the finished, ready-to-use chemicals such as fertilizers, insecticides, so and so on. It will also be worthwhile to point out that PET resin is not any item of mass or general consumption, but is used mainly as a raw material by the further downstream industries.
It has to be understood to be
chemical used in the process of manufacturing a particular commodity.
In connection with the commodity.
Here, my lord, they used, in other items, my lord, they used to use these particular chemicals for, my lord, manufacturing of plastic bottles, jars, containers, and all. In this series also, my lord, yes. Therefore,
Plastic
the meaning.
Bottles.
Yes. More particularly, my lord, for storage of foods and all, my lord. Therefore, the meaning or the sense of the term in common or commercial parlance used to describe PET resin, etc.
It is said it is basic chemicals. That in that sense, it is said to be basic chemicals. Correct?
Yes, ma'am.
What is erroneous about this order? This order seems to be recent. Anything else, Mr. Gogoi?
My Lord, in my Lord, page 60, last line, first para, last line, all these facts lead to an incontrovertible conclusion that the items under dispute is understood and known as the intermediate chemical products by
That's
trade
what I'm
in
saying.
The, my Lord, yes.
There doesn't
Otherwise,
seem
my Lord,
anything wrong.
My Lord, I am obliged otherwise. Yes. But and except, my Lord, this particular page, Lordship may kindly see page 64 and all, annexing certain documents to show what is PAT. There is no evidence to show that it's not a chemical. In fact, my Lord, Lordship will see the diagrams. These are all, my Lord, about chemical reactions, my Lord, page 68. Part of their, my Lord, document.
What is this document at page 62? Is this was this document before the appellate authorities?
My Lord, that I cannot say.
What does it indicate? Because
This, from the
how will
diagram,
this
otherwise the chemical.
how will this court come to a finding as regards? Because these all are very. Yes, Ms. Gogoi. It appears the majority of the world's PET production is for synthetic fibers. This prima facie appears to be a chemical process involved.
Give a compilation of some Supreme Court judgments regarding this. Regarding this point, some Supreme Court judgments. We will give a compilation of that in the next.
Any judgment to indicate that PET resins and PET granules do not fall are not chemicals?
Right now, I don't have.
Well, the cases are fixed. Cases are in the cause list. 2015 matters. You first want adjournments, then you don't carry the decisions that you want to cite. This is not how cases are conducted in High Court. Whether a case is going to be taken up or not, counsel must come full prepared, especially when the matter pertains to 2015. This is absolutely unexpected from the bar. Very unfortunate that all matters are being treated in this manner. At times you may have a genuine ground for adjournment, and this court will also consider, but there is a manner for everything. You cannot take the court for granted. You cannot simply merrily walk and say, I need adjournment because the leading counsel is not there today. You are a counsel, your name appears on record, you must come full prepared. You want to cite decisions, why those decisions are not in your file today? I could have understood if a lawyer of a month or 2 month experience comes and say this. Not from you, Ms. Gogoi. You are an experienced counsel. Yes, when can we have it?
Can we make it part heard, my lord? We can make.
Yeah, my lord. Only, my lord, if it is after vacation, 18 and 19, my lord, I will. 18 and 19, I have got some difficulty.
I'm not making this part heard. And I am vacating your no coercive actions order. I have been sitting with an interim order since 2015.
We fix, my lord.
Item numbers, these are from 12 to 22. Heard Ms. N. Gogoi, Learned Counsel for the petitioner, stop. Also heard Mr. D. Gogoi, Learned Standing Counsel, Finance and Taxation for respondent numbers 1 to 5. Correct?
Hello.
Anybody else?
No.
Stop. The writ petitions are listed for hearing. Stop. Ms. N. Gogoi, Learned Counsel for the petitioner, seeks accommodation on behalf of Ms. M.L. Gope, who is said to be the arguing counsel in the said matter. Stop. Considering that the matter pertains to 2015, this court took up the matter for hearing. Stop. Though Mr. took up for hearing. Stop. It is unfortunate that counsel appearing for the petitioner did not have the relevant case laws proposed to be relied in the matter. Stop. Despite D. Gogoi, Learned Standing Counsel, Finance and Taxation, having completed his argument, because of non-preparation of the counsel for the petitioner, the matter could not be finally decided today. Stop. Leaving no alternative, the matter stands adjourned to
25th.
25/4/2024. Stop. Considering that there is an order to the effect that no coercive action shall be taken by the respondents against the petitioner, by order dated 18/9/2015, stop. Same is not extended further. I think, in fact, Mr. Gogoi, this was only till then. On 8/5/20, I don't find this has been extended.
Only minute.
There is no extension. Is there any extension? Please verify. I don't find. This order. Any other case it is? Is there any extension? Are you aware?
By 18/9/15, my lord, there is an order.
What does it say?
It says, my lord, list on 8/10/25. Till then, no coercive action.
Till then. So till then means till the next date. After that,
no.
Then you say that it may be pertinent to mention herein that though by order, which is that order 8?
My lord, it is 8/9/2015.
There was an observation to the effect that no coercive steps shall be taken against the petitioner till the next date. However, no extension has been seen in the file. Stop. I'm only saying that much.
Yes,
5642.
5642.
10/2015.
Thirteen.
2015, my lord.
Referring to that 18/9/15. Says interim order 18/9/15 passed earlier.
It has been separately extended. Here only it says until further orders. But in the earlier case, yes.
All right, that part I can avoid. Anyway, you will cancel that last part.
Lordship may observe that if on the next day it is not taken up, if then
it is made clear that if the hearing of the aforesaid matters are not in case of further adjournment by the petitioner in the aforesaid writ petition, interim orders passed earlier shall stand vacated.
Highly apologize, ma'am.